but we are lucky to have with us, if I start from down to my very far left, for Keith Blizzard. Keith is a chartered quantity surveyor, a chartered construction manager, a chartered arbitrator, a panel adjudicator, an accredited and panel mediator, an accredited dispute board member, and an honorary and visiting lecturer. So he has all of the expertise and skills for the ADR discussions that we're going to be having today. He's been involved in most aspects of quantity surveying, project management, contract administration, from inception to completion, of a wide range of projects. So thank you, Keith, for joining us today.
Thank you.
Then next to Keith, we have Matt. Matt Drake is the Managing Director of Drake Quantity Surveyors. He's an adjudicator, a quantity surveyor, and a university lecturer. And although he began his career as a heating and ventilation engineer, we're not going to hold that against him today. And then he progressed on to project and commercial management roles. Next to Matt, we've got Luke. Luke is a specialist construction barrister who practices from Four Pump Court. Prior to coming to the bar, Luke also worked in the construction industry, mainly in the Far East. And given his technical background, he has the ability not only to deal with the legal issues that come up in his cases, but also to be able to grasp the nettle with some of the technical issues. Luke is recommended by the legal directories as a knowledgeable, responsive and easy to work with barrister who is also very impressive on his feet in court, and having co-defended with Luke on some cases, I can endorse that description. And finally, to my left is Richard Bailey. Richard is a partner at Druces, which has a strong multidisciplinary team that provides advice and assistance to a range of owners, developers, contractors, subcontractors and consultants across the industry. Richard himself is a highly regarded construction lawyer with a broad spectrum of experience across the sector. Richard splits his time equally between dispute resolution and non-contentious advisory work, and he provides contract review and advisory services to his contractor clients and regularly advises developers on development agreements and putting together suites of contract documents for major projects. So we're lucky to have a really good mix of people with a mix of expertise and experience in ADR in construction disputes. What we've done to prepare for today is pick a few topics we think are current and interesting for discussion. We encourage your participation, so whilst I'll direct some of the questions to the panel, if you have particular questions or insights, we'd be really pleased to hear them. Where we're going to start is whether we think the landscape of ADR and the issues that are thrown up on building projects has changed by the introduction of the Building Safety Act. Richard, what's been your experience so far with the introduction of the Building Safety Act? Have you seen many differences in terms of ADR or the types of resolution people are looking for?
Well, the fundamental point is that claims under the BSA are to be, with open up the, so it's not the adjudication is not the kid on the block in the case of Building Safety Act. It's the first tier property tribunal. So it's asking, has anyone ever appeared before the first tier property tribunal? Anyone got an idea what it is? Where is it? Exactly. If I was a room full of property litigators, every hand would shoot up. Now, when you challenge, wrap them out in a lease, when you've got issues over leases, etc., that's where it's sent. It works on a no-cost basis, like adjudication. So it is somewhat slow. It is technically below the court, where division of the courts, I'm not exactly sure, but is that how it works? But dispute, the way the Act was drafted was, apart from introducing these sudden, desperate nature for contractors of suddenly checking your files for contracts that were more than 12 years old, because that was that moment when he went, oh dear, there's now a 30-year limitation period. I could be dragged in for claims all the way back to 1992. So pre-2000 claims, and you're suddenly looking for your files. Obviously, everything was hard copy there. Most of it has gone in a shredder. So you really got to struggle to find out what you actually construct a building file. So, but on the ADR side, I think the big thing is we're still trying to work out how the first tier property tribunal, which is really intended for unrepresented parties to go and have the dispute resolved by a tribunal member, or whether you go to court where you can seek to get costs, and whether the courts have a wider jurisdiction on what they can award. And there has been a recent court case regarding the tribunal's decision on what is just and equitable, because hidden within the Act is this phrase of compensation that's just and equitable. And at the moment, no one's quite clear, I think it's going to the Court of Appeal, exactly how it's been decided, what just and equitable actually means, and how wide the remit of the compensation is that you can possibly recover. So at the moment, it's very early days.
That's right, and I think because there's new measures involved in the Building Safety Act that aren't just awarding damages, for example, but you can get remediation orders and you can go after different companies to just the contracting party. I think we've got some quite interesting times ahead. In the triathlon judgment, which came out of the First Tier Property Tribunal, one of the first Building Safety Act cases, there was I think it was all construction silks and juniors who were appearing probably in this tribunal for the first time. And the judgment starts with trying to work out how they should constitute themselves as a tribunal. And so everybody at the moment, I think, is feeling their way on Building Safety Act issues and remediation orders. Luke, I don't know whether you've had any experience in that so far.
I think the issue that we have is you go in front of the First Tier Tribunal. The First Tier Tribunal, I'll say this and it's on the record and it's being recorded, but the First Tier Tribunal are used to dealing with replacing windows on a block of flats which need to be replaced. When you say we've got a £5-10 million cladding remediation scheme, they can turn around and say, well, it should be done within 6 months. When you say, well, we can't tender the works within 6 months, they look at you blankly. And I think there's a lot of education to be done in the First Tier Tribunal about the monster that they have been given by the Building Safety Act. And they'll start to understand it, but I think they are... I think Pandora's box has been opened slightly for them. And they are struggling to grapple with the detail of what they are being asked to deal with now, to be perfectly honest.
But there is one point on that, because we're talking, working out who you're entitled to get a remediation order against, who you can actually get compensation, but you can't get them to actually force them to do the work, which the First Tier Tribunal has to grapple with. And also, the other thing that the Act does is it basically says you cannot recover large swathes of costs, so legal expenses that you incur. One of the things we've had to deal with, I've been dealing with, is I've had one block with 116 units in it and doing the landlord certificates once we found a relevant defect. Yeah. But if you read the Act, it says you cannot charge a leaseholder for preparation of a landlord certificate. But you cannot charge it as part of the service charge, you cannot charge anything. But if you're a landlord who only gets their money from the service charge, how do you do a landlord certificate? Mm-hmm. Because you have no money to do it, which means something potentially very riskily and inaccurate might be produced, creating liabilities as well. So it's even more potential risks that are further down the track as well there.
I think that's right. The next... sorry, go on, Keith.
One of the concerns is, from what you've both said, the skill set of the people sitting as the first tribunal.
I don't think it's necessarily that they don't have the skill to do it. It's that previously they haven't had to engage with these issues. And so looking at things like how companies are linked and whether one controls the other isn't something which has naturally fallen within the tribunal's remit to have to consider. Yeah. And so, as Luke says, I think it's a learning process, not just for the lawyers to work out what the government intended by some of these provisions, but for those decision makers to also then try and work through the tests they're going to apply. And as ever, it will be the case law that then informs how we get to a more settled set of principles. But the incredible thing about our industry is not just the ingenuity of lawyers to come up with problems no matter which way you look at things, but the construction industry is a problem solver. And so I think over time we will see the industry come up with proposals to how to deal with things which the tribunals then, I think, will be quite receptive to if they can see the industry trying to engage with the issues. I think part of the problem is that there's a view that the industry sort of turned its back on or hidden it hasn't properly dealt with things like fire safety issues or building safety issues. But I think that there's a sea change on that. And certainly have a huge amount of sympathy for some of my clients who've been involved in cladding cases because they were misled. They were misled by the people who produce these products. It's not a matter of developers saying, well, we don't care whether these products are safe or not. That's certainly not my experience with my clients. But I think there's a sort of general perception that people didn't take these things seriously enough. And I think as the cases come through the courts and through the property, first-tier property tribunal, we might see a bit of a sea change on that as well. We heard from Marion in her introductory address about the case law dealing with mediation. And for those of you who were around when Lord Justice Coulson now, as he now is, but when he used to sit in the TCC as Mr. Justice Coulson, some of you might remember he used to have a sign on his bench which said, "No stays." So he wasn't forcing anybody to go to mediation back then. And my experience is that's led to parties trying to come up with ADR provisions in their contracts so that the first resort isn't necessarily to go to court. And Luke, I think you've been aware of some of the recent case law on ADR provisions and whether those are being upheld by the courts. What's been your experience?
Thanks, Catherine. I mean, I remember Lord Justice Coulson, as he is now, that sign was on his desk, and so it didn't go on the transcript. He used to just point at it.
Yes, he did.
So he would just say, "Mr. Wygas," and then carry on. So there we are. Maybe that's the way to do it. But those of you that know me will know I'm generally not controversial. I generally don't speak my mind, and I generally am not that straight talking. So I'm just going to say it as it is. I'm going to say I think Marion's wrong. I think ADR's over, and I think the pendulum's going to swing the other way. And I might well have said that to get your attention rather than it's what I really think. But hopefully that has got your attention. And Catherine's right. The parties are now saying, look, ADR is so important, let's write it into the contract. So let's say no one goes to litigation or arbitration unless they have mediated. And then no one goes to litigation unless they've mediated and adjudicated. And then you end up with these waterfall provisions within contracts, which, and I've had another waterfall provision where mediate, and there was no adjudication, but there was an expert determination clause and then arbitration. And these clauses are getting increasingly complicated. So in the opening comments, Marion talked about how is the court holding the line in relation to things like expert determinations and adjudications. And is the court saying that those processes should be upheld? Well, undoubtedly it is, and the court is saying that. But with waterfall provisions and these escalations of disputes, what's the court doing there? And it seems, no, it doesn't seem, the courts, in my opinion, are undoubtedly saying it's not worth the paper it's written on. And if you look at the recent cases in relation to waterfall provisions, and probably the most recent one is a case called Lancashire Schools. In that case, there was a waterfall provision that required adjudication of a dispute before litigation. That went before the courts. The courts looked at the waterfall provision and said it's binding, and adjudication is a condition precedent to going to litigation. So if you go to litigation and you have not adjudicated, That is undoubtedly wrong. And it's an abusive process, the claim could be struck out, and all those kind of horrible things. So what the court decided in Lancashire schools, on the basis of previous case law as well, is the court said, well, I'm going to look at these waterfall provisions. I'll decide that they're enforceable. I'll decide that they should have been complied with. And then I'll tell you that actually you really should have complied with it, but just get on with the litigation anyway. It doesn't matter. And I would have preferred you to mediate, and I would have preferred you to adjudicate, but we're all here now, so let's get on with the real deal. And that's what the court is now saying. And even when you say, going back to Lord Justice Coulson, even when you say, well, I want to stay so I can adjudicate, the courts are saying, well, actually, let's not bother. Let's just get on with it. Why don't you serve your defence within 28 days? And so we are getting to a high watermark in relation to ADR, and maybe that high watermark is if you put waterfall provisions in your construction contract and you think the other party must adjudicate before they litigate or arbitrate, just have a care, because that's probably not what the court is going to say. Sorry to be, maybe that's not what the audience wants to hear, but that it seems to be what the courts are saying.
Can it not be the case, though, that adjudication can be quite a good way of finding out what the other side's defence is going to be fairly quickly before you actually have to produce something for court?
No, Keith, I entirely accept that. And I entirely accept that there are good things that come out of adjudication and mediation. And it's not uncommon that I will say to a party, well, let's mediate, and we'll go there and we'll listen. But my point is more, if you think you have got a clause in your contract which will protect you from litigation or arbitration because of previous steps that have to be taken into account, even when those steps are recorded in black and white as condition precedents, don't sleep easy, because you can still get a claim form tomorrow morning.
I think that's right. Unfortunately, I agree with doom and gloom Luke over there. There was the recent Court of Appeal case as well in the Children's Ark Partnership litigation, where there was both the High Court and the Court of Appeal found that a requirement to go to a liaison committee to try and resolve a dispute was a condition precedent and it was binding. But the Court of Appeal said, well, there was no way of that dispute resolution procedure being concluded, and without that it wasn't enforceable. So even when there was a provision which the courts acknowledged was in the contract, again it wasn't upheld. So I think Luke's right. Are there any things that we can do about that? Can we make the provisions clearer? Can we ensure there's a conclusion as the Court of Appeal wanted? Or if you even go to all those steps, are you going to get to court and, as Luke says, the judge just says, but we're all here now, we might as well just get on with it. I think perhaps if you try and contrast the position with these cases with the case which Marion was talking about, where the courts are looking to enforce mediation more, it might be that we're seeing a bit of a tension between these two strands, and it might be with some clearer drafting you might get the right judge on the right day as ever who comes to a different conclusion. I suspect what you have to do is the minute you're served with a claim form is to take action to say this is premature, and to try and get before a judge as quickly as possible so that you're not too far down the line. Has anybody in the audience had any experience of either trying to negotiate these terms and people saying, well, it's all pointless, or experience with trying to enforce these terms? Yes, up at the back.
Yeah, I can talk about it when I give my talk at the front, that I was actually junior counsel in the Lancashire Schools case.
Oh, great. Super. Okay. Anybody else got anything to add on waterfall provisions? They come up in.
Well, I think the thing to say, and I don't want to steal anyone's thunder, but on Lancashire schools, as opposed to the Children's Arc, the provisions were found to be, one of the problems with the Children's Arc is the provision said, well, go to a liaison committee, sit around, have tea, have biscuits, chat it through, you know, and we'll see how things go. And it was not very well, what this liaison committee was not well defined. In Lancashire schools, the provisions were defined, and so that issue of it all being a bit vague didn't arise in Lancashire schools, and the court still said, well, actually, let's just keep going. So even when you've got, to mix my metaphors, a watertight waterfall clause, you're still going to be able to, it seems like you're still going to be able to avoid it.
As a mediator, speaking for mediators generally, when one side turns up just to listen doesn't make the day any easier for the poor mediator.
Do people actually tell you that's what they're there for?
It becomes blindingly obvious.
Oh, that's different.
I've also had it where the solicitor told his client to say nothing, and I spoke to the client. I said, it's your mediation, not his. And the solicitor just sat there saying, he's saying nothing. I mean, solicitor tactics can come into it. Solicitors can be really, really helpful at mediations, and they can also be blockers. And it's the same with actually experts. I did one where there was a whole team of experts, and they obviously were in a room thinking, there's good fees in this court work, isn't there? And they weren't going to agree on anything. But yes.
Sounds a bit like the no comment interview in the police station.
Yeah, yes.
Just tell your client to go no comments.
Or when they turn up, you do the opening, and then you go in to speak to them, and they've got their coats on because they're going. Because they say, well, we can tick the box, we've done mediation.
I think it is quite tricky because certainly in construction projects or the disputes I'm involved in, by the time you get to dispute level, there normally has been discussions between directors or discussions between the parties either coming to the final account or arising out of a particular set of facts if it's defects. And there is, I think, some merit in just letting the parties get on with it if they want to, rather than forcing them to mediation, because most of the time what you really want to see is the other side's documents, because there tends to be some sort of suspicion there's something going on the other side that you don't know about, or that if you got to see their internal emails, it would show you that they think the same as you. Now, obviously, that's not always what happens, but my experience is mediations are not going to be successful if people don't want to be there.
And if they're not prepared.
And, well, quite. I think that's fair too. But you can take, as the phrase goes, you can take the horse to water, but you can't make it drink. And I think the same way with approaching a mediation, everybody has to be there on the same page to try and reach the resolution that everybody could live with, even if they're not happy about it. So
you know you're going to have a difficult day when both solicitors tell you it's a waste of time, you've got to go through the process, we're not coming.
Yeah.
And the solicitors have agreed that they wouldn't come, just sort it out with the parties, have a go, you won't get a settlement. I mean, the one I'm thinking of, actually, I've got a settlement by 12 noon.
Well, McKinnon J in the Halifax Financial Services case described mediation as futile. Now, to be fair, that was on the facts of that case. But that's a High Court judge saying, well, why do it? It's futile.
But it's like you have to jump through it, because as someone who does the front end and drafts these clauses and looks at these clauses, often you get a clause that says you must have meetings of executives before there's a dispute you can adjudicate, which obviously is in breach of the Act, so that can't possibly stop it from happening. So there's this constant tension between these desires to have all these steps, and then you have things like the construction engineering pre-action protocol, which also sort of has a degree of mediation built into it as well. So a court might think, you've done mediation, if you've been through the protocol, you've done that, but you've ticked that box. So I think there's various conflicts, but the reality is you sit there and you advise clients and you go, yeah, that's great drafting, but you can adjudicate whenever you like.
that's right.
Go through it, that's meaningless clause, it breaches the Act, move on.
Yeah. And it'll be interesting to see whether the Supreme Court says you can adjudicate under a collateral warranty, because the appeal's now been heard and we're just awaiting judgment. But the Court of Appeal, who heard the appeal from the High Court, was constituted by Lord Justice Coulson, Lord Justice Jackson and Lord Justice Stuart Smith. And by a majority of 2-1, they held that you can adjudicate under a collateral warranty. And it will be quite interesting to see the Supreme Court, who isn't constituted from construction judges, whether they take the same view of adjudication as certainly Lord Justice Coulson does, who's a great advocate for it. So perhaps this is a good segue into adjudication, which is obviously one of the main forms of ADR in our industry. And we've had some recent decisions at the early part of this year about payment disputes. Matt, in your view, do you think, in light of some of the recent decisions, is smash and grab still alive, or are we now just down to true value?
I don't think it's dead. And I think it will continue. The reason I say that is I think there's a general, it's either a total misunderstanding of the whole regime, whether the scheme applies and the payment terms apply. I find that people representing parties, they don't actually understand what the scheme is trying to do in terms of setting payment dates and the due date, and we've spoken about what the due date is and the final date for payment. I mean, I must speak to plenty of people who say, oh, my payment's due, and I think, well, how many days from the, you know, but then, no, that's what I mean, I'm going to get paid in 30 days, and they don't know, there's a misunderstanding. So just on that basis, that then creates confusion, because if they're agreeing the contract, if there is a contract and there's payment terms, that causes them problems. If they don't agree payment terms, I don't think they're sufficiently educated enough to apply the scheme correctly. I mean, recently I had an adjudication where the representative for the party, and he still amazed me, he was either totally unsure, or sorry, didn't know, or he was just really trying his luck. But he said it was 17 days from the date of each and every application, and it wasn't. And I'm thinking, well, he keeps saying this, and we've had 3 rounds of submissions. So we're working on the basis he can't have been misadvising his client that he was going to win. So he must truly have believed that that was the position it was. Yeah. So I still think we will have notified some disputes. I can't see them changing. The majority, I'd say 90% of the ones where I've been an adjudicator, are to do with payment disputes, notified some disputes, whether it's a valid payee notice or the payment notice or the payless notice is invalid. I just don't see that changing anytime soon.
And have you seen referrals which include smash and grab, but in the alternative, I want you to just value the sum?
Not recently, but it sounds like Keith has.
Go on, Keith.
I have, yes, exactly that.
And
primary position is smash and grab. However, if we're not successful in the alternative, we want a true value.
Yeah.
And I know the recent case was the other way around, but I was very fortunate because I found that the pay less notice was invalid, so they won on the smash and grab, so I didn't have to worry about their second one. And it wasn't contrived. That was genuinely what I dealt with the first one first. And, I didn't sit there and think, oh, this is going to be a nightmare if I have to do the true value. So, no, I just went through and found on the first one. And wasn't challenged.
And what would you do if somebody referred a smash and grab, say there's no pay less notice, and the response from the employer is, well, I accept all the notices, but I want you to do a true value?
Here is the, we can put any defence in.
That's right.
So here is our defence on a true value.
Yeah.
And I think that's the big question we don't know the answer to yet.
Well,
Luke has an answer.
Yeah, I think we might know, I think we do know the answer from the legal point of view, and then let's come on to the practicalities. I think the legal point of view after the global switch claim is, if you want money, the referring party can rely on any defence that they want. And I think so, in a smash and grab, you clearly want money, so you can turn around and say, well, my defence is run the true value, Mr. or Mrs. Adjudicator. That's all well and good, but the number of times you get across your desk a smash and grab adjudication, and you get it a day or a day after the referral, so you've got 6 or 5 days to respond, and you say, we are absolutely dead and buried on the smash and grab, let's run a true value. You turn around to your client and you say to your client, right, I want to run a true value on the final payment application on this £10 million contract. And they say, fine, we can do that. We'll ring our QS up. He'll have a report ready for us in 3 months' time. Yeah. And it'll be great. And you just go, well, it's never going to work. So my view is smash and grab is alive and kicking, not because of the law, but because adjudication is a 28-day process. If I submit a true value, if I start a true value adjudication, I am going to say to the adjudicator, the decision is in 28 days. The pay less notice is 3 days late. It's going to take you 35 seconds to deal with this. Get on with it.
Yeah, because it's not going to, a smash and grab, if it's that simple, does not take 28 days.
No.
Well, the difficulty, I think, with the analysis is we've got a tension in the case law now, because Grove says you can't do a true value until you've paid if you are the employer. Yeah. So the argument against an employer, just in case anybody's against me, I don't obviously think it's right, but the argument against an employer is if you want to run the true value, you've got to pay first and argue afterwards. But that is a bit of a tension now when we look at the decisions that have come out of Bellway and Sergo, because it was all classed as one dispute, both the smash and grab and the true value. So there is, I think, a tension, and therefore, as ever for lawyers, scope to argue, which we love. I think you were going to come back in on it, Keith, on...
Well, as an adjudicator, well, you have to make your decision based upon the submissions of the parties. And therefore, what have they actually argued? Can you do it as a true value? Because the problem you've got is if they run a smash and grab, and the defence is going to be true value, and let's say they have been arguing over it for a long period of time, and then they've gone to legal representatives and they've turned around and said, don't worry about all that. They missed a payment notice there and a pay less notice there. That's out of date, or there was no pay less notice. Just go for that one. So they may actually have the information ready. Then it turns round that the claimant or the referring party is then got the pickle that he's got to get his information together because he's going to have 2 or 3 days.
Yeah, true.
But I think, well, I would hope adjudicators are aware of the law, but I think the legal position is, at the moment, I think it's in a bit of a state of flux, which does give adjudicators some scope to go either way.
Yeah.
But I'm not sure that that's necessarily the settled right position. Go on, Matt.
Just in respect of the question you posed was, have we seen any smash and grab and true value, and dealing with a monthly payment cycle? I've not seen a main contractor or a subcontractor prepare applications for payment in sufficient enough detail that they can instantly provide that with a referral to say, in the alternative, here's our evaluation of work, because predominantly it's an Excel document. There may be a few zip folders, some build-ups of variations, but the main substance of their works will be percentages claimed against valued. That's right. For items on the contract sum analysis. That doesn't mean that they've done the work. So there perhaps needs to be a bit of a change of focus, and a part of people or organisations advising companies who are going to be working on construction projects is work on the basis that you may have a dispute and it's either going to be a true value or a smash and grab. You need to start to provide this level of information with your applications. I know we do lots of M&E work, obviously being a former pipe strangler, as we were called. And I say to organisations, get yourself some drawings printed off. A2 is a good size. Walk around site, highlight 1 month in one highlighter, sign it off. That then can be used as a contemporaneous record that you can then apply a percentage to. Next month, a different colour. The month after, a different colour. I mean, hopefully it's not more than 12 months, because I think you're struggling then with different highlighter colours. But you've then got that record there,
Yeah.
along with photographic records that you can say, look, this payless notice or this payment notice is our time, this is the notified sum. However, if you don't agree with that, here's all our records. Plus, it actually helps, I think, it makes it harder for the person or the organisation paying to deny you what you've asked for.
Yeah.
Because you've got the information that's there. It's easy to just say, oh no, it's not 25%, it's 18%, and that 7% could be a massive amount. So I can't see a good argument being run yet until these companies have got that detail behind them.
I mean, what you've described is exactly what, as a lawyer, you'd look for when you're trying to help your clients with their cases. But the reality is, certainly in my experience, that working on a construction site, the priority is getting the work done, not planning for a case to go wrong or for a dispute to arise as much as we would like it to be.
The operations,
That's what they should be doing.
Operations, they, I do in-house company training, and I said, predominantly they're not commercial, they're operations, and they say, they get a new job in and they're all rubbing their hands. We need to get this subcontractor on board, we need to buy those materials, and we need to do this. And you're always forward thinking, which is great. But then in comes the QS and sits there and puts the black cloth on his head or her head and says, what if it goes wrong? You need to be doing all these things, you need to be collecting these records. And they don't do that, and that is obviously the problem, which means that it takes a lot of time to prepare a case for adjudication.
But the problem with that, to be blunt on this, 90% of jobs never have a dispute, or if they do, it's resolved between the parties. So that level of record keeping. I mean, I have a client who I know they have people walking around site with GoPros attached to their helmets now. So they're filming the progress on site and literally walking around with a GoPro, and they will do an entire walk round.
What an amazing investment.
And they'll film the entire site so they know exactly what the status was. It's all date stamped. But those are on tens of millions, £100 million plus projects. If you're on a 50 grand project or you're a £1 million project, you don't want to have that management resource. We all argue about what the best form of contract is, and NEC's far too management heavy, so you don't want to do that. You want to do a JCT because it's nice and light. So most people are not, their mindset is not prepare for war, because they know that 9 times out of 10, there's not going to be any issue. And actually, most of the smash and grabs I see are where it's actually started to go wrong, and someone sort of go, you missed by a day, which you didn't care about 6 months before, because you knew the money was coming and it was all rolling through.
Everybody was getting on.
You've got a massive loss and expense claim in, and they've missed it by a day. You've got £500,000 rubbing your hands with glee. I'm off.
But maybe the BS, the Building Safety Act, Gateway 2, and the records that have to be kept there, people might actually start to think, we need to get some records here, and maybe we can use this as well for our...
Well, yes, that's going to change a lot. I mean, the whole hard stop at Gateway 2 is going to cause people to really think and design and build whether it even can continue following it. There's a whole argument, that's not an ADR discussion, but a contractual discussion about what the impact of the gateways is upon design and build, design responsibility, your principal designer, which one? When you've got 2 principal designers, so there's all that other stuff going on. It's
as an engineer and a lawyer, it is rare that you hear a lawyer having a more practical answer than a QS. But I think really what Richard has said there about walking around with a GoPro on your head, if you've got a £1 million job, you can afford a GoPro. That's how simple it's getting now to deal with it. And it's great if you've got the drawings and you've got the time to go around and highlight it, it's super. But if you just tell one chap on site he's always got to wear the helmet with the GoPro.
Even once a week, he doesn't have to wear it all day, every day.
He doesn't have to wear it. And no doubt on that day, everyone will be wearing their high-vis jackets and everyone will have their boots on.
He's here.
Yeah, he's here.
I've had sites where they've had external cameras just record the site as it's gone up, and obviously the higher up you go, the more difficult that is. But this happened to be construction of a bus garage that wasn't particularly high, and doing all the hard top outside. So it was a different sort of project, but to have that record, I think, was invaluable. And I think, Keith, one of the things you wanted to talk about today was the different ways of presenting your evidence in different forms of ADR.
Yes, yes. But before I do, I'd like to make one observation. I had an adjudication, and the records showed the number of people on site each day, and they had to go through and have their, I think, their thumbprint or whatever. So they had it like a turnstile, so they could actually prove from the computer records how many people were on site.
Yeah. But just my clients, that they would go missing though on the
Fortunately,
daily charge for most people.
Somebody had realised that at the back of the site there was a gap in the fence, and they actually went round and videoed them, so you could watch them go through and look at the records and then see the video, and they were walking out, and then towards the end of the day they'd walk back through the hole in the fence, come and sign out. So officially, according to the computer records, they'd been on site all day, but they hadn't. I'm going to make a few observations on evidence and compare and contrast arbitration and adjudication and different types of adjudication. And I think a lot of these points are going to be questions rather than sort of answers. But what evidence do you need as an arbitrator, and what evidence do you need as an adjudicator? Is the level of evidence the same in both arbitration and adjudication? Well, and there's also the question about what level of evidence do you need in different adjudications? If you're doing not a smash and grab, but an interim valuation, the parties are a long way apart. How much evidence do you actually need to convince you, on balance of probabilities, that that is the right interim valuation? What if it's a final account? Under particularly the JCT contracts, you've got to prove, let's say, loss and expense. So how many records do you actually need? Arbitration is final dispute resolution, so I think you need full evidence as if you were going to court. But an adjudication depends on what you're asked to decide. Interim valuation or final account. Now, personally, I ask the parties. This is an interim valuation, post-PC. Do you want quick and dirty, or do you want the right answer? Are you expecting me to look at, or the referring party, to prove everything? Ask the parties. Because I've had the answers that, no, we don't want to go to court, we want you, you're a QS, we want a proper job, go through, they should prove everything. And if both parties agree, that's the basis, because it's going to take more time, and the level of evidence you need is going to be greater. And also the difference between proof and evidence. Proof establishes certainty, a fact that demonstrates something to be real or true. Evidence, it supports a claim but may not necessarily lead to a conclusive answer. Written narratives that you receive, particularly in adjudications, are merely assertions. The events, documents, etc. that a party asserts requires evidence in support of those assertions. For example, the parties agreed something. Well, if the parties have agreed something, what evidence have you got? Is there an executed contract? And how many people have actually been involved in an adjudication where the contract's been signed by one party, the contractor, but the employer's never signed it? Loads, because the contractor signs it, sends it back to the architect or QS, and never gets it one back. I always advise clients, take a photocopy of what you've signed. That's the evidence that you need to put in support of the assertion that there was an agreement. Could it be a witness statement? Could it be an exchange of emails? Nowadays, email exchanges are prolific, and you get long email chains, and you get 15-page emails, or an email chain of 15 pages. Now, do you want pages 3 and 4, which are the ones that are relevant to that particular point, or do you want all 15? See what else was said. What about expert reports? Do you want expert reports? Are they helpful? Are they useful? The difference between arbitration and adjudication. In arbitration, there can be a hearing, which means that the other side, and their legal representatives, or the representatives, can cross-examine. So when it comes to arbitration, like a court, there can be proper and thorough investigation. In an adjudication, do you as an adjudicator allow the parties to cross-examine each other? Or, what I tend to do is that if I'm holding a meeting, it's so the parties can explain things that I don't understand or I need more explanation of. And I did one adjudication when it was over works at New Street Railway Station. At the time, my office was 200 yards away. And both parties said, you need to come down to site and we'll walk you round. And I thought, well, I've read the submissions. I don't really need to. But as both parties asked, I said, OK, fine. And at the end of the walkthrough, I said to both parties, I'm really glad you asked me and I came. Because I thought I understood your submissions, but now you've taught me through the job. I now understand them, and my understanding is very different to what it was when I thought before that I hadn't fully understood them. So it's a case really of what evidence do you actually need and what you should provide. Those are my initial comments.
Thanks, Keith. Does anyone else want to come in on that?
Yeah,
on
I want a
evidence?
client that says, do you want it quick and dirty or do you want it right? That's what I think every time I get some papers from now on, the first email back is, do you want it quick and dirty or do you want it right? And that's what I'm going to do. Every day with you, Keith, is a school day, isn't it? You learn something new.
It depends how much they're going to give you.
Yeah.
I mean, it's no one's involved with it, I don't think. But now I've got one that's turned into, I could get it done before, I'm going on holiday the end of next week. I could get it done before I go away. The 28 or the 42 days would finish. Unfortunately, I wrote and told the parties that was going to happen. It's now turned into a much bigger case with a lot more submissions, a lot more argument. And so I had a meeting with the both parties on Teams. And I said, well, the difficulty is, I go away in 2 weeks, which I told you, it was 2 weeks ago. I go away in 2 weeks, and I'm away for 2 weeks, so I'm not working while I'm on holiday. So if you have to give me more time. But the bad news is, I'm already fully committed in July. So if you want me to decide this, then I'm going to have a date, I'll suggest a date at the end of August. And within hours, the respondent said yes, and the following morning, the claimant said yes as well. So in fact, I've now got an adjudication which I have to finish. I've got a report to do for overseas for the end of July, and then I've got an adjudication to get done for the end of August. But that's because they want a proper job, not just a quick answer. If it's an interim, they may just say, do your best. I've had it where parties have said, the claimant has said in so few words, we will give you no extension of time whatsoever. We must have a decision within 28 days. But that's helpful because you then get the parties together and say, right, this is the way I'm going to tackle it. I'm going to do sampling or whatever.
Yeah. What's everybody else's experience in terms of adjudicators calling hearings? I know we've got Matt here who's quite a fan of a hearing. Anybody else got particular experiences in adjudication of having hearings or having site meetings? Yeah.
So that's often
Wait for the mic.
quite unusual on just the smaller type of payment dispute to have any kind of hearing or site visit. But I suppose if you're dealing with defects or you're dealing with maybe some other claims where the physical aspect of it's more important, so limited times where I actually had to go to a hearing or a site visit.
Yeah. I've had quite a few hearings in adjudication. It might be because I'm a barrister, so I like the sound of my own voice and I like going to hearings. It's the best part of my job. But I have had quite a few hearings, and the nervousness for me is that the adjudicator is then sometimes dealing with an incomplete picture. Because in court, whilst it can be an expensive process, you have the process of going through disclosure, witness statements and expert reports. So by the time you get to a hearing, there's a sort of an equality of arms in terms of information, or there should be. Whereas in an adjudication, you're often doing it quite at short notice, and you don't have that equality of arms. And I think that's where Keith's thoughts about what evidence you put together is quite interesting, because obviously as the referring party, you have the luxury of time. Yeah. And as the responding party, you don't. So trying to get an expert report, as Luke said when we're talking about payment, a QS will say, well, I need 3 months. Well, you just simply don't have 3 months. Somebody has to be able to go through it. So I think having a hearing for an adjudicator, particularly who's dealing with a complex dispute with a lot of issues, is helpful to cut through what the parties are trying to say. And I don't mean to pick on you, Matt, but I've had Matt say to me, I don't really want to hear from the lawyers, which makes me nervous. I want to hear from the clients or from the experts, the people who can actually give him the information he needs to make his decisions. And so some cases I will really resist a hearing when I know that's going to be the approach, because if your client isn't used to these procedures, if this is all something quite new to them, they don't necessarily know that the way they might answer a question could give an impression that they did tend to give. To put it neutrally, I think. Anybody else? Sorry, go on.
I think the great thing about adjudication is the flexibility of it, isn't it? And my favourite adjudication meeting was held in a lift, and we had a day in a lift going up and down. But there we go, and then the decision was made, and that was that. So there we go.
Was it quick or dirty, or was it right then?
I think you have to depend which side you're on.
Just really an observation of when you're saying about experiences of having hearings. We actually did some internal research, and over the last sort of 15, 20 years, less than 1% of adjudications have a hearing. So your experience might be different because you're going to get instructed in a case where a hearing might take place, and therefore it might be slightly skewed. But over 1,000 adjudications, less than 1% is what we came up with anyway.
I think that's probably right, because a lot of them will be smash and grab. And so it will just be, you won't need to hear from the parties. It's a paper-based process for a reason. And for what it's worth, I think it was Matt said he doesn't think smash and grab is dead. Nor do I. I think the courts are going to uphold smash and grab type approaches because you have to pay now pursuant to your notices. And it's, in my view, if you don't have a proper payment notice, you don't have a basis for a true value, because the only basis for payment, either in your contract or under the scheme, will be pursuant to serving notices. So if there's no notice, there shouldn't have been a basis for a true value. And the way, so one view of Bellway is the court had to enforce the decision, because whether the adjudicator got it right or wrong doesn't matter. But it doesn't necessarily mean the adjudicator came to the right answer in that case. So I think it will be interesting to see how the Bellway cases play out, and we're still having them. Arguments about payment disputes, 25 years after the Act came in. So I think interesting times ahead on that. But perhaps if there are murmurings in the industry that true value is going to become more prevalent, we might see more contractors investing in a GoPro or some sort of evidence gathering techniques that don't actually involve a lot of time investment, but if you need them, you've got the evidence to back up the valuations. And of course, your payment notices are supposed to be accurate representations of the sum you think is due if you're a contractor, and if you're an employer putting in a pay less notice, the sum you think is due. So there should be somewhere some reckoning of how you've got to those figures, and if they're not genuine, they're not valid notices. But of course, trying to prove that in an adjudication might be difficult when you don't have the same disclosure obligations as in a court process.
I think that disclosure obligation is one thing. Increasingly, when you see adjudications, you see a highly selective, especially if someone had plenty of time to prepare, a highly selective submission that would never get past the court, because there'll only be if there is no obligation, sometimes you see a statement of truth on the bottom of a witness statement, but I don't think they're actually bound by any of those obligations in adjudication, of just sort of whatever evidence might suit you. But also, the problem with the way things are going, Keith mentioned 15-page emails, videoing, all this kind of it creates so much data now that those who work in courts on a regular basis will be discussing disclosure obligations and electronic disclosure and searches. You can't look at 5 gigabytes of data as an adjudicator
in 28 days.
So,
Yeah.
Are there so many, it comes back to Matt's point actually, I think, the way the LDEDC was drafted and the terminology with the due date leads to so much confusion, and I think that's why, or a contributing factor, as to why we have so many smash and grab adjudications, because people just don't understand what is meant by the due date.
Yeah. Well, thank you very much, and thanks for your participation.